Hey, I got a question this week from a parent who is I guess a co-signer on a car that they have for their child who's going to college. And the question was, since I'm part owner, title owner of the vehicle, and the child's going off to college, what should I do to protect myself as a parent from potential negligence of the child after he or she goes off to college? Well, let me just start with the basics. In Florida, as the owner of a vehicle, even if you're a co-owner, if you have any kind of right to possess the car, you're potentially liable for that car under Florida's dangerous instrumentality doctrine. The owner is responsible. If the owner is 2 people, 12 people, 14 people, all people are responsible in Florida for whoever's driving that vehicle, if they have permission. So that's the short answer to your question. The parent has a right to be concerned that they might have some liability for what goes on in that car if they're the title owner. The next question was, what should I do as a parent if I want to protect my assets as a parent from any delinquency or negligence that my son or daughter could cause off at college? Well, the best way to do that is to not be the co-owner of the vehicle, right? It would have to be a legitimate sale, if you will, of the vehicle to the minor. You'd have to redo the title with the tax assessor's office, tax collector's office rather. So you have to redo all that so that the title is then reissued in only the 18 plus year old's name. Of course, they have to be 18 or older to be owned property. If you do that, then of course the child has to get their own insurance because your policy no longer covers that car. Everything has to be in that, I say child, adult child's name in order for you to be protected, and your name cannot be as the owner of the vehicle. But that's not the only way that you can get hooked into liability. If there's an argument, for instance, the child's home from vacation and is at your house, or home from school rather, on vacation, and is at your house, and they get drunk in your house, or you know they're drunk and they get in their car, you could be sued for negligent entrustment of the vehicle since it's technically being stored at your house. So this only protects you, this moving the title into the adult child's name, only will protect you if the event happens away from your house. If the event happens and your adult child is living at your house, there's probably going to be a way to try to get to you as a parent, but it's harder. So if your name's on the title and you want to protect your assets, you better get your name off the title. You better get the car reissued in the adult child's name, and the adult child has to get their own insurance policy. That's the shortest way to get from point A to point B. There's repercussions to that for the child because the child then is no longer insured under your policy, which if they're involved, if they're a victim of a wreck, they don't get to take advantage of your car policy to help them potentially. So you need to be aware that that might be the case also. If you have questions about any car wrecks, we represent, of course, the people that are hurt. If you have any questions about car wrecks or any kind of personal injury case, you can find us on the web at zarzaurlaw.com, or you can call us at 855-HIRE-JOE. Thank you.